Thanks, Jeremy. So yeah, we're here to talk about neutrality and space law. A big topic, lots of potential things to talk about. So the plan that Josh and I have, Major Wolff and I have, is we want to lay out a few basics, tag a few issues, but really we're both of us are really looking forward to the discussion portion of this. So you know, consistent with what you heard before from Jeremy, we're both comfortable if there are questions while we're doing this, that's great. But the intention is that there'll be lots of time for questions and discussion at the end. So just bear that in mind and push. And as I'm looking at my screen here, I don't see any I don't have the chat function up. And that is a technological failure on my part, I am sure. But Jeremy will jump in and ask your questions if we have them. So with that, let's jump into it. Generally, here's the agenda, not dissimilar to what I said. We're going to look at just an overview, some of the general rights and obligations under the law of neutrality broadly, and then we're going to look at some particular applications in the space domain. A quick chat about some of the remedies, and then we'll be right into the questions where really anything is fair game. So let's jump to the next slide there. So in general, I get to give the general comments on neutrality. And I will say that, you know, when I started getting presented with neutrality issues, it had been something that, you know, stirs around in your head, but it was mostly because it was assigned to me on a certain project that I'm involved in. It wasn't something I was saying, you know what, I need to talk about neutrality. And it's one of those things that, you know, I think a lot of us have been in operation centers. We've done planning. The word neutrality doesn't come up all that much. And, you know, I've talked to some of my classmates in the, you know, space operations folks, and we don't use the word neutrality much, but it is a really important area of law because I think it both underpins and reflects the sovereignty and territorial integrity based state system that we have. Obviously, you know, when you say those things, you get red flags for space application, but you know, neutrality, even though we don't use it by that name, it is all around us in how we do military operations. And I think it's a really important area. Also, just speaking generally of neutrality, I think it's like it's a good way to kind of hold a mirror up to yourself as a lawyer and see what you like and what you don't like. Because if you like order and clarity and knowing exactly what the rules are, neutrality is not for you. However, if you really enjoy really tough questions about where does it come from? What does it say? What does it say here versus what does it say there? And working through those issues, then neutrality is really neat. It's also a great area because I have trouble thinking of another area of law where you just can't separate the law from the geopolitics. So many of the things that neutrality drives, especially when you're talking remedies and, you know, what those even are, which we'll get to later, you know, it's hard to figure out what the law is from a, you know, consistent state practice and a sense of opinio juris perspective, because there are so many pragmatic reasons that states might not assert what their legal rights are in a neutral context. You know, just because you could do X, Y, or Z to another state, you might not want to for a host of other reasons. So that really makes it tough to know what the quote hard and fast rules are to the degree that they even exist in neutrality. So that's the introduction. That's my general bullet. And you'll notice throughout this, I think we might have more questions than answers. But that's what the discussion section's for. You guys, this brain trust here on the net is going to answer all the questions. It'll be perfect. So applicability. Neutrality is driven when by there being an international armed conflict. It's not something for NIACs, non-international armed conflicts. So it's not part of LOAC per se, but it follows along with LOAC, the Law of Armed Conflict, or IHL, the things that are triggered by use in bello rules. But it's not necessarily part of those. It exists independently. And this is another area where I think neutrality is very interesting because it has elements of the use in bello, what you can and cannot do, who you can and cannot do things to. but at the same time, it has these very important jus ad bellum. You know, are we going to go to war with this other state? Are we at war with this other state? Implications. So it's a really interesting area of law in that regard. It kind of floats between the two, but absolutely it is triggered by international armed conflict. Now, that is not to say that neutral obligations or obligations similar to those of neutrality don't exist otherwise. They just go under other terms, like in a NIAC or just in periods of tension. You have non-intervention is a principle that kind of accomplishes a lot of the same things that neutrality does. And so what is the general purpose of neutrality? In a nutshell, it exists to essentially respect sovereign rights, to not be involved in a conflict that a state does not want to be involved in. The overall goal there is to preserve, peace and friendly relations among states. And neutrality is designed, and it's been designed for a couple hundred years to accomplish that. So that has been consistent throughout the existence of neutrality, and I think that continues on. It's a mechanism for friendly relations, or at least peaceful relations among states that do not want to be in conflict. So to the definitions, we got a neutral state. That is a state that is essentially not party to an armed conflict, an international armed conflict. It doesn't necessarily require a formal declaration of neutrality. And a lot of states that have declared neutrality, Switzerland's an example, that's more of a political position or a policy position. That's not really neutrality in the sense of a particular conflict. So when we're talking about neutral states, we're talking about there is an armed conflict, and vis-a-vis the belligerents, who are the parties to that armed conflict, who are not parties. It's a relational definition. It has to be relative to an armed conflict. There's also this concept of non-belligerence. This one is a little more controversial, but essentially it has been pitched that you can be not a belligerent, so you're not a party to an international armed conflict, but you're not entirely neutral as well. This has not caught necessarily on. I know, I believe the DoD Law of War Manual asserts that it's possible, but even acknowledges that it's controversial. Essentially, the idea is if a state is a victim of an act of aggression, for instance, so they are genuinely a victim state, if you provide some degree of support to that state, it's not bad. It's not a violation of the law of neutrality necessarily. This has not been tested a lot, but it's a concept that's out there, so we're throwing it out there as well for consideration. And then finally, there's belligerent rights. A lot of the ideas of neutrality, what you can and cannot do, should not do if you prefer, are driven by the armed conflict. And so belligerent rights are essentially those things that a state can do during an armed conflict. Typically, you in your practice of statecraft cannot send your military around and blow things up or kill people. But in an armed conflict, you can do that. The use of force is kind of the core essential belligerent right. But there are other things as well that might run afoul of other obligations you have in a regular context, but there are certain things that you can do while you are in an armed conflict. Again, most of those, overwhelmingly, those are vis-a-vis the other belligerent or belligerents in your conflict, not necessarily neutrals, but those assertions of belligerent rights are kind of what neutrality is centered on helping define. And then the last thing, the sources of law. The concept of neutrality goes back a ways. In 1856, there was a Declaration of Paris, which is a beautiful thing. It was 4 points. It was back when international law was short. But really, it talked about sort of the rights of neutral vessels and what parties can and cannot do. It essentially got rid of, the idea was to get rid of privateering and to make some of the actions in blockade a state level action, as opposed to just sending out letters of marque and having privateers that would have otherwise been pirates running amok. But it developed a little further, and the core text that we have for some of the law of neutrality comes from 1907, you know, the whole package of Hague declarations, but Hague 5 and Hague 13 are the core ones for that. Now, the issue there is that Hague 5 talks about warfare on land. Hague 13 talks about war at sea, and they are tied to their domains. You know, the texts of those the Hague regulations they are domain specific, and so then that doesn't apply to space, right? What goes on land doesn't necessarily apply to outer space. Now, Josh will touch on that a little bit here in a minute, but it's a challenge. And so that's why you got to look to, you know, what is the customary law of neutrality? And that's really where the debates get interesting on how this applies to military space operations generally, but also in particular, military operations in outer space or on the moon and celestial bodies. So that's the big issue. There are different views on this. It is my view that there is a customary law of neutrality, but I will also concede that it is not particularly well defined, and it's really hard to draw a very specific customary law that you can make all that actionable. So it's a challenge, but really, I think it's like a lot of areas. You just have to ask yourself, is the law of neutrality a domain-specific law only, or are there some transcendent aspects to the law that apply to the behavior of states, you know, irrespective of where the state is operating? I happen to believe, from, you know, what I've looked into this, that there are some aspects of neutrality that transcend domain. But again, as we'll get to in a few minutes here, they're vague and they're hard to pin down. So anyway, let's jump to the next one there. So basics. So you can look at the different rights and obligations in two buckets. There's the obligations on the belligerents, and then there's the obligations that a neutral state has. And so for belligerent obligations, essentially, you have to respect the territory of a neutral state. So if you really want to do a kinetic kill ASAT, you should not move your TEL onto somebody else's territory and launch it from there, or you know, do a sea launch one from their territorial waters. That would be a no-no. That would be violating their neutrality. And that would be unauthorized entry. It also would be committing hostile acts on neutral territory. Those are the big, clear, general rights and obligations for the belligerents. There's also neutral state obligations, and that is really non-participation and impartiality. Those really go together. Generally, you as a state should not be participating in the armed conflict. To the degree that you can do or allow certain things to happen, that, you know, these are some things that Josh will talk about, you need to do it impartially, which is, you know, not to the prejudice of one belligerent or to the benefit of another belligerent. And then there's also a duty in some circumstances to prevent violations of basically the prior two, the non-participation and impartiality. But as we have the little stars there, the scope is unclear. And a lot of these, you know, these sound like particular obligations. And if you're thinking that, you'll be right. And they're particular because they come from especially Hague 5, but also Hague 13. And as mentioned before, when we're talking particular, we're probably talking about a very domain, either land or sea specific set of rules. So that makes it complicated. You know, what are my obligations in an impartial context when we're beyond those domains? I think a lot of that law and practice has yet to be written. So anyway, I think that that hits the introductory portions. I'll kick it to Josh just to refresh me on what I forgot to mention from what we talked about there, and then he'll take it from here.
Okay, thanks, sir, and good morning to everybody, and thanks to Major Gruner for setting this up. I agree with what Colonel King is telling you here. I would highlight a couple of points from these first two slides that I think are worth just either one thing to walk away with, and also will kind of pave the way for the rest of the discussion. The first is when we talk about it only applying during international armed conflict. I think that's important to just foot stomp from a practitioner standpoint, because a lot of times when you have states that are below the threshold of that international armed conflict, they may be doing operations or activities against and with one another below that threshold in sort of a competition phase that may involve third states. Now, that is not going to invoke neutrality. It will likely involve other principles of international law, like Colonel King mentioned, potentially non-intervention, almost certainly questions of sovereignty there. But anyway, I just want to foot stomp that because I think from the practitioner standpoint, a neutrality can kind of get conflated and pushed into the evaluations when we're below that threshold of armed conflict. So I think that's important. The second piece, it will also tie in as we move forward here. When we talk about that duty to prevent violations, it is really focused on a neutral state's duties to prevent belligerent states from violating that neutral state's neutrality. So it feels a little circular, but the reason I'm highlighting that is because it is not about the neutral states, well, or the scope, where the scope becomes very unclear is whether that neutral state and to what degree it would have a responsibility to prevent its nationals or any person from conducting activities from its territory that violates neutrality. And why is that important? Well, as we get further in, we'll see where neutrality kind of pulls apart things that the neutral state is obligated to do, which is basically much more restrictive, and things that the neutral state national is allowed to do, which are much more expansive. And space law tends to conflate that or compress those, I would say. And you may ask, why is that the case? Why would neutrality permit some activities by their nationals? And you know, to cut to the point, it's generally commercial activity by the nationals that a neutral state engaged in would violate neutrality, but the nationals may engage in the same without violating neutrality. Well, it goes back to what Colonel King said. Part of the purpose of neutrality is to preserve friendly relations. And I would add onto that, that you could either say that the friendly relations are a means towards this or is its own purpose, but it's also, neutrality is designed to ultimately prevent the spread of armed conflict. And so from a commercial standpoint, permitting the neutral state nationals to maintain, continue commercial relations reduces the adverse effect of the armed conflict on the neutral nationals and therefore the neutral state. Theoretically, you can see a connection there of why that might reduce the spread of an armed conflict. So with that, we'll keep moving here and try to get into some of the areas where we think are critical to look at for the application of neutrality for space-based activities. And we're gonna arrange this in where we think the clearest, I stopped short maybe of saying a bright line, but the clearest applicability or at least analysis is, and we'll kind of work our way into the muddier waters from there. So the first piece we'll talk about relates to ground stations. And what I would say the clearest, the closest thing we have to clarity on that would be prohibition of belligerents building a new ground station in neutral territory, putting a new one up in neutral territorial waters during an international armed conflict. And not to insult anybody's intelligence, but just to back up a second, because I realize we may have some people tuning in or watching that are not regularly involved in space operations. The ground station is what, you know, the satellites, they have all the data, either they're collecting it or just transmitting it, but that is of no use unless and until it gets back down to Earth by way of a ground station. And because of a satellite's given orbit or its design in a constellation, those ground stations physics means that they can't be just anywhere on the Earth and function properly. And so they may need to be placed around. So that's why I would say it's of significance in the perspective of an international armed conflict involving space-based activities. So if you look at here, we have two rules, one from Hague 5, again, that is the treaty that relates to land, conflict on land in Hague 13. And they're, I think, fairly straightforward on prohibiting construction of well, they use the term wireless telegraphy, right? Or any other apparatus for the purpose of communicating with belligerent forces. So I feel like that is actually fairly straightforward. If you were to, if a state during an armed conflict wanted to construct a ground station in a neutral territory for use with military satellites, I think that this rule certainly speaks to that pretty clearly, that that would be a violation of this neutrality. Again, now you could argue whether it is communicating with belligerent forces on land or sea, if it's just a what we would call a TT&C, telemetry tracking and control stations, because maybe that's only talking to the satellite. But I think that that's maybe not the strongest argument, because ultimately, if that satellite is providing data through another means back down to a belligerent for use with its armed forces, I think it's probably within the scope of this rule. And as you can see, I just want to highlight here some of the difference in language. So on Hague 13, they couch this rule as sort of what I would say is that how Colonel King described the non-participation norm or custom of neutrality, forbidden to use the neutral waters as a base of naval operations. And then it goes into, in particular, using this to construct the wireless telegraphy. So anyway, I just kind of wanted to highlight that because it's interesting that that language appears. It seems to be more of a big picture, we'll carve it down in Hague 13, whereas you just don't see that in Hague 5. But either way, I think in the case of constructing a new ground terminal, I think that we're fairly within that ambit. Now, we start to get less clarity if we're talking about continued use of existing ground stations during an international armed conflict. And here, so the bottom one there is still from Hague 13. It's the same provision because Hague 13 doesn't split it up. But the top one there is a little bit different. It says, use any installation of this kind established by them before the war. So we're talking about established by belligerents before the war on the territory of a neutral power for purely military purposes and which has not been opened for the service of public messages. So you read that, you kind of get the impression that maybe the negotiators came upon this like on a Friday afternoon or something, because it is not a picture of clarity. It's not, what do you mean by purely military purposes? Is that referring to the use? Is that referring to the original purpose of constructing this wireless telegraphy station or other apparatus? And what do we mean by opened up for the service of public messages? So these terms are not extremely clear. Remember, we're talking about something that was signed, entered into force in 1907. So it's understandable that it may not lay on very well with today's technology. But I think that there are a couple ways to look at this. I think the first one is if the ground station is used for multiple purposes, and as long as one of those purposes is not military, and if you consider one of those non-military purposes to be the service of public messages, again, not a whole lot of clarity on what that means from the treaty itself or from state practice, but if you are in that bucket, then it appears to be permissible. Now, again, that's just kind of the ordinary meaning reading this language. Now, there is an alternative reading that I think, if you look at it more in context, if we were to put this in context and say, okay, well, if a belligerent constructs this station on the neutral state's territory and continues to use it during an armed conflict, I think there's an argument that it would, if that were permissible, that it sort of makes that preceding clause, the prohibition on permitting construction of a new station, sort of illogical. And here's my example. So if state A constructs one of these stations in the neutral state's territory, state N we'll call it, in 2020, and then enters into an international armed conflict with state B in 2021, we have some issues. Let's say state B wants to construct a ground station in the neutral state in 2021. Can they do that? No, of course not, right? We just said that that's probably one of the clearest applications of neutrality to space-based activities, that they're going to be prohibited. But if A is allowed to continue to use it, we certainly appear to have sort of a impartial handling of this, right? And I would further argue that if you take it in object of enlightened purpose, or at least I would point out, if you take it in object of enlightened purpose of the treaty, that is what? To preserve friendly relations and prevent the spread of armed conflict. Well, if you think of how state B would view state A's ground terminal located in the neutral territory, they're going to probably see that as a valid military target, right? And we could talk a little bit about remedies later on about what they're allowed to do. But you can certainly see how it kind of undermines the object and purpose of the treaty to say continued military use of that would be permissible. I'm not saying that either one of those arguments is particularly clear. Again, the language itself is not super helpful. And state practice has not painted any lines on this, but I think particularly as we see telecommunications privatized, we just don't have a whole lot of answers to fill in those gaps. But in my mind, those are kind of the two arguments and two directions that you could go with that. So if that is unclear, let's get to super unclear and talk about neutrality and activities actually in outer space. Because as Colonel King mentioned, one of the challenges here is that the most detail we have are from those Hague treaties. Those are domain specific and they don't refer to the space domain. So let's talk about whether and how we can discern neutrality might apply to space objects. And when I say space objects, for me, that's just gonna be shorthand for satellites. So one of the arguments goes that, that neutrality does not apply to space objects because if you read the language from the Hague treaties, again, the most specificity we have on neutrality, it's always talking about territory, territorial waters, all territory based. And the argument is, well, on the Outer Space Treaty, Article 2 says that there's no national appropriation by claim of sovereignty. So there's no sovereignty in outer space. If there's no appropriation by claim of sovereignty or any other means for that matter, then there can be no territory in space. If there can be no territory in space, we're not worried about neutrality applying there. Pretty straightforward and a pretty strong argument based on the plain meaning of Article 2 from the Outer Space Treaty. Now, a counter argument there would really say, well, space objects can constitute something called quasi-territory. And if you're not familiar with this line of argument, you could look at Article 8 of the Outer Space Treaty, which says the state of registration for a space object is to retain jurisdiction and control over the object. Okay, so jurisdiction and control, if you have jurisdiction and control, really jurisdiction generally flows from a sense of sovereignty, a jurisdiction to prescribe and to enforce. And so if Article 8 confers jurisdiction and control over those space objects, in fact, a duty to retain jurisdiction and control over those space objects while in outer space, the argument is, well, there's a quasi-territory and they have a duty to maintain jurisdiction and control, particularly when you add that to Article 6 responsibility. There's a fairly strong argument that there is a duty to regulate that. Now, whether it constitutes territory, again, you go back to Article 2. I would point out that I think Article 2's language gives a little bit more leeway than some argue for this quasi-territory, meaning it's going to apply, meaning that neutrality would apply to space objects. And that is this. If you closely read Article 2, it talks about outer space, the moon, and other celestial bodies. So those areas of outer space are not subject to national appropriation. But it does not reference, like several other articles from the Outer Space Treaty do, man-made objects or space objects in outer space. So I think that Article 2, I find that to be a persuasive argument, but I don't find it to be locked tight because it does, in my mind, leave open the idea of that a man-made object could constitute quasi-territory or even can be considered territory because the state maintains property ownership of it if it's a state object in outer space, as you can see from Article 8. And Article 8 confers jurisdiction and control over the same. So I think, again, it's not really settled. We don't have a ton of state practice telling us how states view that, but it is an interesting point, and kind of you see whether we're going to actually say the satellite itself is subject to neutral obligations and rights is an open question. And I'll try to wrap up here talking about what I think is another very difficult area for neutrality in space, and that is that distinction between neutral states and neutral states nationals. And I highlighted this at the beginning of my talk. If neutrality really carves out some leeway for neutral state nationals. There's a couple of examples on the slide there from Hague 5, where essentially the state doesn't have to prohibit use of the wireless telegraphy apparatus, right? So private citizens or even its own telegraphy apparatus, it's not obligated to prohibit use of that by belligerents. And then Hague Article 7, from Hague 13, Article 7 says that neutral powers aren't bound to prevent the export, right? They can't export it themselves, this arms and equipment and ammunition, but they're not bound to prohibit it. And so there you can see we're carving it out. Again, as I highlighted, that's basically the compromise, the aim to preserve commercial relations. Now, I would add that the private citizens do that at their own risk. There's no guarantee of it being safe just because they're a neutral national, but it's not on the neutral state to prescribe those actions. And then when we look at Article 6 of the Outer Space Treaty, it's a pretty unique idea in international law where the states are going to bear international responsibility for all national activities in outer space. And that includes those conducted by non-governmental entities. So again, that is a big jump in international law, and where neutrality pulls apart the neutral state and the neutral state's national rights and obligations, the Outer Space Treaty sort of pushes them together. And so I think, to me, the question boils down to how far do you read that Article 6 from the Outer Space Treaty? Do you think that it is all the way on the spectrum to attribution, meaning essentially anything that those non-governmental entities do of that state or of those states' nationals that they do, is that attributed to the state as if a state's own organ or Department of Defense conducted it? Or is it something less than that? Is it more of we're pinning a rose on somebody, so to speak, to make sure that activities in outer space are regulated, but we're not, and by pinning a rose, I mean there's actual international responsibility for failure to do so, but maybe it just imputes a standard of care and not so much immediate attribution, so to speak. So, sir, that's all I have, unless I'll pause here for a minute if you think I left anything out from those, and then we can transition maybe to discussing remedies, unless there are any questions at this point.
Yeah, I tell you what, how about I talk remedies just real quick, and then hopefully that generated some questions or concerns or issues. But yeah, so now that all the rest of that is clear, we'll move to the muddy area of remedies, right? So for belligerents, let's say that a neutral state's violating its neutral obligations. What can a belligerent do? Well, certainly there is the tactical level or operational level of self-defense. I mean, if they are being attacked by either a neutral state or the forces of a neutral state or some actor from that neutral state, they can defend themselves. There's also the issue of seizure. This is an interesting one where I think there is evidence that there is to go back to what I talked about earlier, are these domain-specific rules, or are they an extension of domain-agnostic prerogatives? And it's fuzzy and it's unclear, but a lot of seizure comes from the law of the sea or the practice of states during neutrality and during blockades. I know that there's been a bit of examination of that in the air context, which is a much more challenging endeavor from a practical standpoint to actually seize. You can intercept, but to seize aircraft. But the Harvard Air and Missile Warfare Manual, they looked at that, and it seems like there is some degree of seizure and intercept as part of the law of neutrality in the air. I don't know that we have that in space, but it seems like that could be on the table. Again, not because they do it in the sea, but because potentially that is something that sovereigns do when they're in an armed conflict and they think that somebody is running goods to a belligerent under a neutral flag. So I have that as a remedy. I don't know that it's actually solid, but that is a remedy at sea, and it's something for consideration in the space domain. And then finally, you have just traditional military ops. Basically, if that neutral state, if you're a belligerent and you think that a neutral state has acted in such a way that they are essentially a party to your armed conflict at this point, then you would consider treating them like one. What the threshold for this is, I don't know. I would think it's more than one individual act. That doesn't automatically, you look to your jus ad bellum rules basically. But when you have tests like your effective control, are they actually controlling the individuals that are doing things to you? At what point does that amount to an actual attack or an armed attack that would trigger a right of self-defense or draw them into the international armed conflict? Those are all very tough questions. And as I said at the outset, They are very geopolitically loaded questions, but there is a point at which a neutral state, either through its own state actions or potentially through actions of its individuals that it allows, it is no longer acting neutral. And if you're not neutral, you're basically a belligerent. I think that's a long way to get there, but that's on the table for a belligerent party. So for neutral states, let's say a belligerent has violated their rights as a neutral state. They can certainly ask for reparations. Countermeasures are on the table. I skipped retorsion because retorsion always makes me cringe. It's, you can be unfriendly to them, but not do anything that would otherwise be illegal. You can do that. I think you could do that anyway. But so retorsion's an option. But countermeasures, you can take actions, and I mean this in the international law remedy countermeasure sense, not in a more practical counter what they are doing sense. But basically, you can violate your obligations, basically telling them you need to stop what you're doing, or else we're going to stop doing what we're supposed to be doing with regard to you. So countermeasures in that sense. There's also the use of force. If that mobile tel example, you want to be neutral, but one of the belligerents rolls an ASAT tel onto your territory and is going to launch from it, you can use force to stop that. That you would be within your rights to do that. And that would not be construed as support for the other belligerent. It would be merely an exercise of your rights as a neutral. And again, if you're really fed up with it, you can decide you're not neutral anymore and join the other side. That is certainly an option for states to do. So that's obviously a very nutshell view of remedies. What I think we're going to do now is kick it to Zoom, and I think Josh and I have all kinds of views on all kinds of things with this, but I would love for us to direct it towards what you all are interested in or wondering about, or to hear your thoughts. So I think next slide's questions, right, Josh? Yeah, all right.
Awesome. Well, gentlemen, thank you so much. I have been monitoring the chat. I see that we have a question from Professor Vanderdunk. His question is, would seizure also be applicable not to a satellite as such, but to the ground station controlling it, possibly on the territory of a state not originally targeted by the seizing state?
That's a good question. Somebody make that guy a law professor, right? That's I think that would be, this is where the geopolitics might completely overwhelm the law. I think you could make so actually for seizure, I'm not sure. I think it'd be easier to make an argument to target that thing, to neutralize it or destroy it. To actually seize and occupy something on someone else's territory, that would be a big step away from what I think the seizure really looks at, which is state actors, or excuse me, individual actors, not states, though they have the flag of their state, on the high seas, which is, the res communis, or how, I don't think we say that in DOD, but, the on the high seas. I think to do it in someone else's territory, you could make arguments to it, but that would be certainly that puts your rights as a neutral, or excuse me, your rights as a belligerent up against the territorial integrity of a neutral state. And I just think that territorial integrity is going to win, both prudentially, but also as a matter of law. But it is absolutely going to be an issue or a challenge. Josh, I don't know, maybe Josh has the right answer. I was just stalling to let him collect his thoughts.
Thank you for that, sir. No, I don't have the right answer, but I do think it raises a very interesting question here, in that we're really measuring against this territorial integrity, sovereignty, protection that neutrals enjoy, against that right of the belligerent to maintains the right of self-defense. And so part of me says, well, if I'm allowed to target it with lethal effects, which I think, we're going to assume for this case that that ground station is contributing to the, would meet the definition of a military objective. If we're going to assume that, I feel like seizure would be, in a way, short of it. However, you're not going to be able to do it without violating the sovereignty of the neutral state. So it's a very interesting, it's a very interesting question there, looking at basically balancing those competing rights and interests. And then I see your follow-up there, sir, on the virtual one. To me, that cuts even further. Well, okay, people could have an argument about sovereignty and cyber. That's clearly outside the scope of what we're talking about here. But it is also clearly below the threshold of sending an actual military unit or some other forces to seize the station. So I think there that we're not in as much balance. And I feel like either, because when I read your question initially, I thought you were talking about basically seizing data. And in my mind, I was thinking of a cyber operation to do so. And in there, I think that we're at least arguably at a lower risk of this, or at least a reduced sovereignty interest by the neutral state. And so I think that it might be more, I guess I would find that to be less likely to be a clear violation of neutrality, but I'll defer over to Colonel King and see if you have any thoughts on that too, sir.
No, I mean, that's good. I agree. It's hard.
Great. Well, thank you guys so much. Our next question comes from Professor Beard. Professor Beard asks, accepting that many parts of neutrality law seem to be domain specific and thus not applicable to space, what kind of behavior by a neutral country satellite could be described as not being impartial or as participating in the conflict?
So I'll throw something out. I think that well, look at Google Maps, right? Or say somebody has a remote sensing platform. They can do nice pictures of Earth, and it's open and available to everybody who just wants to download it. I think that would be that is an example of impartiality. So if, let's say you have two countries, state A, state B, they're on some other continent entirely from the country that has that capability. It's open to everybody, and they're both going on their their phones or their laptops or whatever, and doing their targeting based on those maps, equally available to everyone. I think that is impartial. If, however, the ostensibly neutral state decides that it likes state A more than state B, it gives state A the codes for the special higher res, down to a centimeter fidelity that really makes all the roads passable, or so they can see where all the passable roads are. They can really execute their operations better, and everybody is conscious of this. I think that could be a violation of impartiality on the part of the neutral state. And again, I guess if you're relying on Google Maps to do your targeting and maneuver, then you probably don't have a lot of options for taking care of an offending satellite in outer space. But we'll consider that as we'll just make that we'll ignore that limb fact on the scenario there. But I think treating the parties differently with your space capabilities would be a violation of impartiality. Josh?
Yes, sir. So when I think of impartiality versus the non-participation duties, I think of the impartiality as applying to government policies or decisions. And so in the case that Colonel King mentioned, if it's, let's use the GPS satellites as an example, if there's an enhanced capability of them that a neutral state authorizes one of the belligerents to, I think that is, but not the other, I think that is a violation, would be a violation of both. But again, that's really the state's policies that are violating that, and not necessarily the satellite itself. Now, if you, I don't know sort of exactly how tightly you want to parse that question on the satellite itself, given that you're talking about the domain limitations. But so I see it as in the case of where you're allowing use, and again, we're talking about state-owned satellites, or maybe by means of your own regulation, requiring a company to allow some sort of use that to one belligerent or the other of that, the capability that satellite provides. The challenge again, though, is that when we're talking about, those are things that are obviously happening on the Earth's surface. Those are decisions by the government, and or maybe data provided, that are received on a ground station, and not necessarily the satellite itself. So I take it's well taken that the domain limitations make it difficult when we're looking at what the satellite itself are doing. But the flip side of that is, again, that data is of no use unless and until it gets down to Earth and is provided to some user. And so I think that kind of, to some extent, resolves, or I would say resolves, but provides another basis to look at this through the neutrality lens.
Great. Well, we have additional questions flowing in. Deborah asks, what about hosted payloads when the hosted capability performs a military function?
Yeah, so this is one of the things that makes this issue in space a nightmare. So even if you believe it applies and you think that there are clear rules, there's going to be an issue of, well, who's the neutral here? And who? I think that ties into the question. Josh talked a little bit about Article 8 and registration, and then obviously there's a registration convention, but that doesn't create. That creates registration. It doesn't create nationality like a flag on the high seas. So when you're dealing with those issues, irrespective of who may have paid for the cargo or what other cargo is on this ship that's on the high seas that might get intercepted, there's a flag, and so you can at least say, okay, this thing belongs to that country. I think registration is fuzzier than that. At least I think registration is fuzzier than that. There's kind of different ways you can look at it. You can say, you know what, registration is what we got in space. That's what we're going to go with. But I just think the totality of circumstances for exactly, the heart of that question, I just think it's going to be so much harder in outer space. And so what about hosted payloads? Well, I think a lot of this boils down to, do you want to do something about it or not? If you're going to go to claim reparations, you build your case and you complain. If you think you have to make an acute targeting decision, that's going to be harder, and you're going to have to weigh the gravity of the offense that you feel is being committed against you against the risk of collateral harm to those other the other things that might be on that satellite bus. But it's a hard issue, and I think it's something that all the U.S. Spacecom planners are going to have to work out, because I'm just some guy at Air War College. But it's a really good issue to consider. Josh?
Yeah, I really don't have a whole lot to add onto that, sir, but it does bring to mind sort of the complexity of when we're trying to figure out who is the neutral state on any given space object, given that there are different ways to measure it. I mean, Article 8 is not the one and only one. In fact, I would say that Article 6 is probably much more instructive on that in terms of who actually has the duties over that. And so I think the bottom line is, it's pretty messy and complicated. I think it would be helpful if we could see, again, and I think that time will bring us this, how states handle, and maybe not in the context of armed conflict and neutrality, but how they handle allegations of international wrongful acts and their Article 6 responsibilities there. That might kind of instruct us and see how those connections should be played out, and how specifically they might inform us a little bit on how it might play out in the neutrality context as well.
Yeah, just real quick, I just want to jump on that. That's one thing that I believe that firmly, and I don't think I stressed it enough. This is an area where, states write international law. This is an area where I think there is a lot of room for states to define the contours of how neutrality works in space. I guess that sounds kind of obvious, but that is very important. I think there are some things that are settled, like there is neutrality and you're generally supposed to be impartial as a state, but the contours of all of these matters is really going to come down to state practice. And that's why it's so important that the folks on the line are thinking about these things, because it will matter down the road. Sorry to do the soapbox thing there, but I just wanted to jump on that.
Great, thank you, gentlemen. Our next question comes from Professor Mostashar. He asks, what would be the position if there's perhaps a neutral state that's providing servicing to all, but in a conflict services one of the belligerents?
I can jump in on that one, sir. I think that, again, so I'm thinking about the limitations and boundaries that we have from the domain-specific treaties from The Hague. And I think that Hague 5, if I understand the question correctly, that Hague 5 would not prohibit that as long as there is, this goes to the impartiality requirement of state policies. So, for example, if there was some export control mechanism that cut out one of the belligerents but not the other, that would arguably be a violation of neutrality. Now, this is where that non-belligerence discussion that Colonel King mentioned at the beginning makes this extremely complicated, because you can have, you kind of borrow the language of constitutional law, you can have a facially neutral policy that clearly has an adverse effect on one, like puts its finger on the scale, versus one that's clearly, clearly cuts one of the belligerents out. So the latter, I think, is a clear violation of neutrality. The former, I think, is more of a form of non-belligerency, which, while is not a consistent state practice, has been one that has cropped up, particularly throughout the 20th century, late 20th century. And so it kind of makes that a difficult issue. But I think the baseline rule is there's no obligation to terminate it to one or both belligerents just because there is a armed conflict. But if you terminate to one, you should terminate. The general requirement is to terminate to all.
Great. Our next question comes from Major, or at least Major Select Sample. He asks, he says that he notices the DoD is considering using rockets to transport military cargo. If that cargo contains a weapon, would that bring up neutrality concerns if it crosses over neutral territory? He follows that up with, is this another airspace delimitation potential issue?
So, yeah, that's neat. I will read you Article 2 of Hague 5. So to the degree that we're talking on territory, it says belligerents are forbidden to move troops or convoys of either munitions of war or supplies across the territory of a neutral power. So I think, not that I'm reading ahead here, but I know we have a question, does Hague 5 even apply to a lot of this stuff? If you think that these transports, at least to the degree that they're flying through the airspace and landing on the land, the territorial land of a neutral country, carrying munitions, I think that could be an issue. And this is another area where that whole Article 6 angle gets pretty important. If you're responsible for all your space, if the state is responsible for space activities, how tightly do you read that as attributing it to the state directly versus the state having an obligation just to, is it directly attributable to the state, or is it just something the state needs to look at more in the context of like an Article 11 or an Article 17, I think it is, of the Hague, where that talks about what the state's obligations are vis-a-vis its personnel. But I think it's absolutely an issue. And with a lot of this stuff, you just have to think about how the other belligerents are going to view it. So, even if you might say you're okay as a neutral, if one of the belligerents say you're not okay, that is certainly a political factor for you to consider in whether you really want to pursue this line of effort. Josh?
Yeah, the only thing I would add to that, sir, I mean, it's a great question. And I think it's spot on to identify that this is really relates to delimitation. And in my mind, just to echo Colonel King's point, it's important that the people involved in this Zoom or in this field think carefully about the consequences of establishing a delimitation, because that is a maybe one of maybe many hidden areas where the territorial consequences of delimitation might have a unintended or unforeseen consequence. So thank you for that.
Great. And gentlemen, would you say that we hit on Mr. Jarman's question? Colonel King, I know that you somewhat addressed that. Major Wolff, do you have anything to add to?
Yeah, I think, and thanks for that question. I think that, and I apologize for not highlighting this, it's a fair question, but I do think that the language, there's a little bit of a, remember, these are from 1907, so they do say a wireless telegraphy station. They say, or other apparatus for the purpose of communicating with belligerent forces on land or sea. And so I have, you know, the benefit of just reading that right here in front of me right now. But I do think that that qualifier of or other apparatus, I think that encompasses the ground station if it's for that purpose. And again, so you could say, well, is it for the purpose of communicating with land or sea forces? Does that limitation apply? Does that mean if it's just to aircraft or to satellites, for example, does it not apply? I think that's a fair question. In my mind, when I think of the purpose of that provision, I think that what they're talking about is really any wireless communication in support of military operations. But admittedly, that is not precisely what the text says. So a fair question, but to me, I think that the or other apparatus language kind of gives us that carve out. And so apologies for dragging this out for that, but I did want to address that. So thank you.
With respect to kind of the effects of damage to or an attack on a satellite, you know, it seems pretty likely that various countries could be affected by an attack on a satellite, depending on what the satellite was, et cetera. With respect to that sort of thing, would you anticipate that whether it was the physical destruction of a satellite, whether it was the you know, computer-based hacking of a satellite, the blinding of a satellite with a laser, et cetera, to the extent that an attack on one of the belligerents' satellites has follow-on effects for neutral countries, for instance, it seems like potentially, depending on what a satellite could do, those effects could be even more severe, perhaps, than what would traditionally have been considered an attack on that neutral state or a hostile act on that neutral state's territory. Would you consider that to be a violation of a neutral state's neutrality that would encompass some of those remedies that Colonel King, you were speaking about before?
You know, I consider myself a LOAC guy who does space stuff and is interested in it. And I have I have a disposition. And while I think that what states do in armed conflict, again, because states create the law, is going to get a little bit of a heavier vote in how they do this. So I would tend to think or tend to expect a state to employ, obviously it's targeting rules, but do a proportionality analysis, and it should be a robust proportionality analysis. So there is an appreciation of all those collateral effects. But I think that is going to be the assessment more than, you know, you're not going to treat neutrals necessarily any better than any civilian or non-combatant objects in space. I think that's the gist of how I kind of look at it. That doesn't mean that's right, but that is what I anticipate where it would fall in that analysis. I think, you know, we have had awesome questions, and so I really appreciate that. But in case there was a complete set of crickets on the line, you know, afterwards, we had a few things at the end. And I think one of them was, hey, with regard to neutrals, you know, is there an extra obligation? Because you're not at war with this country. And now, while you're not, in your question, you're not directly targeting those things. If there's going to be substantial collateral impacts, is there like a duty to warn? Is there something extra that's out there? And I think, you know, there's a reason we put it in the questions for you all instead of the questions that I want to answer. Because that's a tough one. I think what you're talking about kind of gets to that. Is there any extra thing you have to do? But again, from my view, I think I would defer to my targeting and proportionality analysis to include precautions in attack and all those things, but it wouldn't necessarily be as much of a neutrality analysis. So Josh, tell me I'm wrong.
No, I was thinking along the same line, sir, and primarily because that's where we have clarity, because I don't think, legal clarity at least, because I don't think it's outside the norm to think, well, if there is this, if we're going to take as a given, and it's not a given, but if we consider the custom of neutrality to provide some protections for the neutral states, some general protections to not be adversely affected by the belligerent's conduct, well, I think that the question, the facts presented in the question raises that issue. But the trouble is, where's the clarity? How do I know, you know, the belligerents still maintain their right of self-defense? And so if I'm going to look at, well, what bounds are there on that? To me, the only area we have clarity on that would be in LOAC and targeting principles.
And I'll just note too, you know, again, you go to the core of neutrality, it's about, not to fall back and hide behind the domain specific stuff, but it's about protecting the territory of those countries, right? And when we're talking about these activities in outer space, it absolutely affects the neutral states' activities in outer space, you know, again, in your question, but it's maybe less existential to the state and to where that a lot of these neutrality rules come from. So I think that's a factor as well. Over.
Great. Well, thank you so much, gentlemen. I have not seen any new final questions roll into the chat. Gentlemen, do you have any final words for our audience, or would you like to cap it off?
I'll just say, I really appreciate, like I said before, all the questions are awesome. This is a really neat area. I encourage everybody to keep digging into it, because you get all the exciting aspects of space law and all the exciting aspects of military operations, and you get them, instead of meshing together, you get them butting heads. And I think that's just a fun thing to deal with as an attorney. And, you know, I'm glad everybody's got great questions. Keep asking them and answer them, and let me know, because I certainly don't have all the answers. And thanks again to you, Jeremy, and Jeff Biller for putting this together. It's been great.
Yeah, I just echo that, and really just thanks for the opportunity to talk this morning. Thanks for the great questions. Clearly, some folks were at least able to pay attention through all that, and I appreciate that. So thanks again to Jeremy and Mr. Biller also for putting this up. Thank you.
Awesome. Well, Colonel King, Major Wolff, we really can't thank you enough for your participation in this webinar series. Very, very great presentation. Thank you for sharing your knowledge with us today. And to everyone else who is still on the line, you know, thank you so much for tuning in. Thank you for your participation. But thank you all for your participation, and we look forward to seeing you in future webinars.